My previous paycheck, I made 17,000 and I only received $800 of my pay. I financially cannot afford that. I'm 24.
It's not, whether you can afford it or not is not really a relevant issue for the, excuse me, not a relevant issue for this court to consider. All right, the court now is calling case number 24-152-517. This is Auto Club Group. The matter is before the court on the filing of objections to a writ of garnishment. The matter is before the court as a result of a judgment that was entered by default on the 15th of August, 2024 for $19,778. I'm looking for Auto Club, Counsel for Auto Club to be on the Zoom. Please say something at this time. All right, do I have Valencia Harris on the Zoom? Please say something if you're here. Take yourself off of mute, ma'am.
I'm sorry, I'm here.
All right, good morning. Good morning to you, Ms. Harris.
Good morning.
All right, I see that you filed objections to the garnishment, and in your objections, you indicated you never received the garnish, never served papers of garnishment documents properly. Tell me what you're talking about, ma'am.
So in 2021, I was involved in a car accident. A young lady T-boned me while I was driving with my children. And so fast forward, I just received notification from my job on, I believe, the 20th of last month that my wages will be garnished. I was never personally served any papers anytime around the actual court date for August. All of this is pretty much new to me as far as them garnishing my payments. But the garnishment has already happened. I tried to call the creditor to get more information, and their representatives were very rude to me. I was just trying to understand what exactly it was for and try to figure it out. And the young lady basically told me like, oh, well, I don't do any legal advice, so you better just call you a lawyer. But we have documentation saying that we took you to court or whatever she said. I personally cannot afford to do 25% of my pay. I have my actual paychecks pulled up as well. My previous paycheck, I made 17,000 and I only received $800 of my pay. I financially cannot afford that. I'm 24.
It's not, whether you can afford it or not is not really a relevant issue for the, excuse me, not a relevant issue for this court to consider. You filed objections to the writ of garnishment, and your objection says that you were not served. I have a document establishing that you were served.
I was not I'm sorry.
I'm going to be quiet and let you talk, and then I'll make my ruling. Go ahead, since you want to interrupt.
No, I'm realistically not trying to be rude. I have just been going through a lot trying to get this together, and everybody I talked to has been rude to me. And I've never been through no type of lawsuit. I'm just trying to get it fixed up because 19,000 is a lot, especially when at the time of the accident, nobody was found at fault because by the time the police came, my car was in a gate and I had to figure out how to get me and my kids together. And I never get any information. They never, I'm sorry to be emotional. I've never received no papers from them. And I was pretty much blindsided. And so when I was asking questions, they would not give me information. They just said somebody served you papers. I never had papers. I would not be negligent to not appear to court to defend myself over $19,000. I also have neighbors that live 2 doors down from me who address looks very similar to mine, and we have issues where we trying to figure out where each other packages are going. So maybe they could have went to them. I don't know personally. Okay, I do apologize if it felt like I was being rude. Okay, you all, but I'm just really emotionally distraught trying to figure it out, and I just don't have no help doing any of this. And I'm trying to get my money together because I'm sorry. I just have not paid my rent, my light bill, everything, and this is just my life up. And I was not wrong When that young lady hit me, my light was green. She came down so fast and hit the front of my car before I can even pass anything. Her insurance company never asked me, hey, how did this happen? Nothing. They just straight up sued against me. I don't know how to go about any of this.
Anything else, ma'am?
No.
The court rules do not allow the court to consider issues regarding the underlying case. File an objection to a writ of garnishment. Writ of garnishment is a post-judgment matter, and so what happens is that the only thing that you can raise in the objection are issues like we've already paid it, we filed bankruptcy, things along those lines. If you believe that the judgment should not have been entered, there's a different type of motion that you have to file. It's called a motion to set aside default judgment. And you file that motion and you raise issues regarding what you believe happened before the judgment was entered. I'm prohibited by court rule from considering issues that may have occurred before the judgment was entered. The hearing today is a post-judgment hearing. It only addresses what happened since the judgment was entered. And since the judgment was entered, the plaintiff is seeking to recover money based upon a judgment that was entered against you. The reason that they got that judgment entered against you was because they filed a proof of service. And that proof of service document that they presented to the court says that on 6/3/2024, that the process server signed an affidavit saying that he served one Valencia Harris at the St. Alban address at about 3:18 on 6/3/24. They described someone 5'4". They indicate a weight, African American, and no glasses. They said the person was about the age of 24 years old. If for some reason you believe that they did not serve you, you certainly have the right to file a motion to try to get that judgment set aside. But that's how the case gets to where it got to now. Also, issues that you might raise regarding whether or not you were at fault in the accident, those are issues that you would raise in the underlying case, not in the post-judgment. Because the judgment is already entered against you, you can't raise those issues unless you can get that judgment set aside. And that would be your business, I guess. If you believe you have a basis to get it set aside, that's what you would want to do. I would caution you, of course, that if you decide to file those kinds of issues and you come to court, if you hear a judge talk, you probably want to not interrupt, because that doesn't go real well if you decide to interrupt after you've been given an opportunity to talk. So that's probably not a good way to go. Now, having said those things, I want you to understand that it sounds like what you need to do at this point, it sounds like you may very well need to try and get some relief from some of the consequences of the garnishment while you go about the business of trying to find out what to do with trying to attack the underlying judgment. So I'll address that in just a moment. Madam Counsel, what matter are you on?
Good morning, Your Honor. Tori Lomas on behalf of Auto Club Group.
All right, so I just got done allowing Ms. Harris to speak to the court regarding her objection to the writ of garnishment, and she raised issues saying she was never served the lawsuit, that she was not involved in the accident, and of course the court rules prevent me from taking those issues into consideration on objection to a writ of garnishment, because that is a post-judgment issue. She also indicated to me the hardship associated with the garnishment at this time, and that was the issue that I was getting ready to address. She did not file a petition for partial payments, but I was getting ready to address that issue to see if in the interim she might want to address payment voluntarily and decide whether or not she wanted to file a motion to try and set aside or to work out some kind of plan with the with audit law. So, Ms. Harris, you indicated that you had been garnished one time, that they took money from one time out of your paycheck. Is that correct, ma'am?
Today will be the second.
So, have they taken money once already? That's my question.
Yes.
The next question is, how much money was taken the one time that they took money?
Hey, my job escrowed it for
I understand that. Listen, Ms. Harris, let me make this up. Ms. Harris, how much money did they take from you, escrow or whatever, on this judgment? How much? About 800, 700, 600,
it was I'm pulling my pay stub up now so I can tell you. It was $394.84.
Thank you, ma'am. Okay, so what that means is that your garnishment rate is about $800 a month because you get paid twice a month, correct?
Yeah.
Is that correct, ma'am?
Yes, I get paid every 2 weeks. Yes.
I got it. Okay, so that's about approximately $800 a month, ma'am. And you said you had 2 children, correct?
I have 4 children.
And how much is your the rent or your mortgage?
My rent is $13.25.
Do you have a car, ma'am?
I do.
How much is your car note?
$300.
You pay insurance on your car, do you, ma'am?
No, not currently. I don't operate my vehicle as well because of that.
Got it, ma'am. All right, so do you pay utilities, or are they included in your rent?
Yes, as of right now, I have a DTE bill that is $424. And my water bill, I was on a payment plan. I got kicked off, so now I have to pay $102.
I got it. All right, so counsel, any issues with regard to? I know that there's a garnishment in place. I've already signed an order finding that there is not a valid reason for the objection to the garnishment. I'm considering now granting the petitioner some relief under some relief from the payments that she's indicated for their hardship issues are. Counsel, anything you wanted to add at this time?
Yes, I do, Your Honor. At this point, there has been no payments made. I understand withholding has just begun. However, the total amount of this judgment is just about shy of, it's around the $20,000 mark. So that is going to be a while to pay off, even at the $800 a mark. It's still a long time payment, and if it's lower, it's just going to extend the length of the judgment and possibly set that up for a renewal again.
All right, so what you're dealing with, obviously, Ms. Harris, is you're dealing with a large judgment. You do have a right to file a motion to try and get it set aside. I mentioned to you that contained within the file there is a document that's been applied to the court as proof of service. That's how the judgment was entered. And I know that with your rent being the amount that it is, and there obviously being a car note and other expenses as well as for my children, that the $800 a month does pose a significant hardship that you do, in fact, have this. You do have this judgment that you got to deal with. What I'm going to do is I will reduce the garnishing amount. You got a big judgment. I wish I could reduce it smaller, but I'm going to set it at $125 per pay. So that's going to be $250 a month. That takes you away from the $800 a month. And I'll review it. I'll make it reviewable in 6 months, counsel, because the size of the judgment is the biggest issue here. Sometimes when people have a judgment that's maybe $2,000, $3,000, I can set that payment at $50 a month or whatever, but because the judgment is almost $20,000. The normal payment for that type of judgment on a payment plan is like $500 a month. But given the circumstances of Ms. Harris, I'm going to reduce it to $125 per pay period. I'm going to go ahead and set that up under the garnishment. I'm going to order that the garnishment will continue, but they can take no more than $125 per pay period. And let's go forward. And again, it's reviewable in 6 months, and I'll put the 6-month date in there. The parties can address that issue again at that time. Again, because of the high amount of the judgment. Right? And you still have the right to file to try and get the judgment set aside if you believe that you have a basis to do so. Okay? That is my order, and you receive my order in the mail. I do wish both sides well. Thank you.
Thank you so much, Your Honor.